I'm Tom Slade, a lawyer with Supreme Advocacy LLP in Ottawa, Ontario, Canada, and today I'll be looking at responding to applications for leave to appeal at the Supreme Court of Canada. The Supreme Court of Canada is the end of the line. There's no further appeals, but often appellants first have to get permission or leave to appeal to the Supreme Court. The best way for respondents to win at the Supreme Court of Canada is to stop the appellants from getting leave to appeal. Only about 10% of applications for leave to appeal are granted, and once a leave is granted and it goes to the appeal stage, the odds change to about 50-50 in terms of whether the appeal will be allowed or dismissed. For respondents, you want to put the time, effort, and resources in at the leave to appeal stage to try and stop the case there. Today I'll be looking at 5 practical strategies for responding to a leave to appeal, as well as 5 technical compliance tips. Number 1, the facts. The applicant on a leave to appeal to the Supreme Court has to convince the Supreme Court that the case raises a legal issue of public importance. That means something that has an impact on the law generally, and that goes beyond the particular facts or parties of the case. As a result, the facts are often the weakness of the applicant. The facts are what make a case unique. So if it's one of a factual dispute, then it's not a case of public importance. So a respondent can focus on that weakness and argue that a case is really just about the facts and doesn't raise any legal issues. Number 2, the law. The applicant will attempt to raise a number of issues, but at the application for leave to appeal stage, there's really only one issue: public importance. The actual merits of the case, for now, those are secondary. They really only become significant once you actually get through the leave stage to the appeal stage. To the extent that you have to get into legal issues, you want to focus on the fact that perhaps a court of appeal or another Supreme Court decision has already settled the legal issues in this case, and as a result, the courts below were simply looking at a factual case, or were looking at applying settled law to a set of facts. If you make your response too much about legal issues, you risk breathing life into the applicant's application for leave to appeal, and in effect making the case look more interesting than it really is. Number 3, the issues are local. If you can argue that the case is only significant to a particular location or to those particular parties, then say so and explain why. The Supreme Court Act doesn't refer to national importance, but often something that is of national importance would be considered to be of public importance. So the opposite can also be true. Something that's not of national importance, that is perhaps only important to a particular area or a particular group of people, that maybe has a less chance of being of public importance. Even a case that's about a particular area or location is of public importance. The Supreme Court may still decide to defer to the highest court in that area for the decision. So, for example, if a case is coming out of Ontario dealing exclusively with Ontario legislation, the Supreme Court may want to defer to the Ontario Court of Appeal, as they would likely have a bit more familiarity with those laws and legislation. Number 4, the case has been fully dealt with below. As a respondent, as much as possible, you want to convey that the trial judge and the Court of Appeal have fully dealt with the case in their decisions below. They haven't left any loose threads, and there's nothing really left to be decided by the Supreme Court of Canada. Everything has already been settled. So even if it's a potentially interesting case with interesting legal issues, you want the Supreme Court, when they're reading the leave application, to be thinking that it's already been fully resolved and that really there's no need for them to intervene. And in cases where you have the Court of Appeal below agreeing with the trial judge, you want to make sure you point that out right at the beginning of your response. You basically want to send the message that, okay, we already have 4 judges, the trial judge and 3 at the Court of Appeal, who have all come to the same conclusion on this case. And even if there are interesting issues, it's already been decided. Number 5, the case is interlocutory in nature and not final. Typically, criminal matters don't get split up as they move through the courts. So that means the first judge looking at it will decide all the issues in that case before it goes up on an appeal. However, with civil litigation, that's not always the case. Sometimes parties may try to get a case dismissed before there's even a trial. Or there might be a dispute over disclosure of evidence. And those little issues can go up to the Court of Appeal before there's ever a full trial on the case. So in those circumstances, you, as a respondent, want to make sure that you emphasize that this case is really only interlocutory in nature and not really a final disposition of the whole matter. The Supreme Court, when considering the leave application, may be impressed by the fact that this matter really has a number of years to go, even if they decide to rule on it, and that may encourage them to not grant leave in it. Summary: a practical way to respond. Putting all those strategies into practice, one way to respond is as follows. First, argue that the case is just about the facts, and it really turns on the facts. It's a factual dispute. Second, you want to argue that the decisions below fully resolve the case, and there's really nothing left for the Supreme Court to look at. Third, you want to focus on the fact that the case is really limited to those particular parties, and regardless of how this decision gets decided, it won't have an impact beyond the particular parties to the case. Fourth, you want to limit the case to the particular locality, province, territory, area, whatever you can do to make it look smaller and less of national importance. And fifth, you want to make it clear that where possible, this isn't a final judgment and really it's just an interlocutory type issue, and there's a lot left to be decided even if the Supreme Court decides to get involved at this stage. A strategically well-written response should be focused, surgical, and sleep-inducing. Seriously, you want the Supreme Court or whoever's reading this leave application and then reading your response to think that there's really nothing to get excited about here. There's nothing that they need to look at. Everything here is old legal news, and they can just pass on this case. Technical compliance. In terms of technical compliance, here's 5 quick points to keep in mind. 1, page length. Whatever you do, don't exceed your page length. Don't try and play around with the font or the margins. Put things down to 11.5 or move out the margins 0.1. Basically, they're seeing thousands of these documents at the Supreme Court, and you don't want yours to stand out for the wrong reasons. So you have 20 pages to do a response, and ideally the best responses are half that length. Number 2, spacing and font. In terms of spacing, your document should all be 1.5 spacing. The font should be 12-point font throughout. And for footnotes, they should also be 12-point font, which looks a little bit weird, but that's the requirement. And if you have any sort of argument in your footnotes, anything more than a citation, those should also be 1.5 spacing. So effectively, the court's trying to stop people from just jamming in lots of stuff into their footnotes. Number 3, hyperlinking. The court's been moving more and more towards electronic, and with every passing year, there's a greater expectation of having hyperlinking in your documents. So now the table of authorities at the end of your memorandum, that's expected to be fully hyperlinked. You no longer have to include excerpts of legislation that you rely on. Instead, they want you to hyperlink to the particular section of the legislation. Number 4, documents to include. In terms of documents to include, for a respondent, you don't need to include anything that the applicant has already included in their leave application. So if the applicant, however, has perhaps missed a decision below, or you feel there's some document that is relevant and really important to the issue of deciding leave, then you can include that in your response. Otherwise, typically most responses only consist of the memorandum of argument. And number 5, signature. Last but not least, don't forget to sign it. All right, that's it. So that's 5 strategic points, 5 technical points. Hope you enjoyed. Thanks for watching. If you're interested in more Supreme Court of Canada news, please sign up for our newsletter. We do a weekly newsletter every time the Supreme Court releases a decision or judgment, and we put out quick summaries. And you can also check us out on Twitter for a little bit more quick breaking news.